Hey guys, welcome back to the channel. Today we're breaking down the explosive final chapter of the trial everyone's been waiting for, where Judge Perkins steps back into the courtroom and delivers a complete reality check in true masterclass fashion. This time, he's facing off with young sovereign citizen, Jamil of the family Lockhart, and things escalate fast as legal arguments clash with courtroom authority in real time. If you thought part 1 was intense, part 2 takes it to an entirely different level, sharper exchanges, bigger tension, and a judge who isn't holding anything back. Let's jump straight into it.
Mr. Lockhart.
Yes, hello?
Are you, you've been here before, correct?
Yeah, I've been here before.
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart. Appearance for the record, please.
So I am Jamil of the family Lockhart. The motions that I filed and the documents that I have filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay. Your Honor, the Constitution grants this court 2 criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 17 of the Constitution.
Honestly, what kind of logic is this guy running on? He suddenly starts throwing around Article 1, Section 8, Clause 17, the so-called enclave clause, as if it magically supports his argument. But in reality, that clause simply defines the federal government's authority over specific areas like the District of Columbia, giving it jurisdiction to manage federal land and facilities. It doesn't back up the claim he's trying to make at all. Instead of strengthening his point, it just ends up showing a complete misunderstanding of how the Constitution actually works.
So in which of these 2 criminal jurisdictions does the court intend to try me?
Where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings and conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
to disclose it to you. Check the court rules, sir.
Well, Your Honor, the 6th Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand which jurisdiction the court intends to proceed to conduct defense.
You have a very good attorney on the line, Mr. Elwood Terry. If you want to speak to him in a breakout room, I can give you that opportunity. Other than that, I'm going to set a bench trial or a jury trial in the matter.
Okay. Please let the record show that I have attempted to understand or to ask what is the jurisdiction of the court is operating under. And it appears that the court is operating under a secret jurisdiction, maybe only known to bar members and licensed attorneys. So let the record show that I am trying to understand jurisdiction and nature of cause against me, and the court has denied me that information.
I'm not denying you the information. The information is public information, sir. The information is outlined in the Michigan court rules. You need to read the Michigan court rules, and you can find out jurisdiction. It'll tell you everything about jurisdiction. That's entirely public information. You can go online and type in the court rules. The whole book is ascertained to you online.
Sir, the 6th Amendment grants you to inform me of the nature and cause of any action brought against me. And right now, you are denying that right.
Sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving, drive while license not valid or improper. The other charges, no insurance, misdemeanor. The allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration on that vehicle.
I understand the
maximum cost. Don't interrupt me, sir.
Okay, go ahead. I'm sorry.
Those are the charges. Do you want a bench trial or a jury trial?
Your Honor, I am trying to understand the jurisdiction of this court.
And as
I said, you told me it was a criminal jurisdiction.
If you read the Michigan court rules, the Michigan court rules will tell you and give you jurisdiction. So they have a copy of the Michigan court rules online or at the public library. I'm sure it is easily ascertainable, and we're not going to keep going down this road, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that. It can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question. You're just.
I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution is exercise of the constitutional right cannot be converted into a crime, sir.
You can't really get addicted to acting out in court in a literal sense, but you can keep landing yourself in contempt if you refuse to follow basic courtroom rules. And while the Sixth Amendment does guarantee that you must be clearly informed of the charges against you, it doesn't guarantee that you'll personally understand every legal detail or interpretation involved. That responsibility sits with you and your legal counsel. The court's job is to ensure you're informed, not to make sure you fully grasp or agree with the law.
Sir, the way you speak to the court is via motion, okay? If you have a motion that I've already denied one of your motions, if you have another motion,
under what basis? Under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules, sir.
So there's only two jurisdictions which this court can operate under.
You're going to be treated just like any other lawyer that comes in this courtroom. So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it admiralty law?
There's no such thing as subtract morality law. What is likely trying to reference is admiralty law, but even that argument falls apart in this context. Admiralty jurisdiction applies to maritime matters, not everyday courtroom proceedings, and it certainly doesn't extend to situations where there isn't a ship, a sea, or any form of navigable water involved. If anything, a quick look around the courtroom would make that pretty obvious. That brings his first appearance to a close, but in his second one, the pattern repeats itself. Once again, he sits through the entire docket, not to resolve anything, but seemingly just to continue challenging the judge at every turn.
On the record for Mr. Jamil Lockhart.
Yes.
All right. This is the last time I'm going to say this. I'm not going to continue to go back and forth with you regarding court rules and all of those positions that you have. If you put it in a motion, we'll set a motion hearing date.
If you are setting a motion hearing date, you are doing so without my understanding of the nature and cause of the action against me.
Listen, I
cannot move forward until I have these questions answered. These are basic questions that you are obligated under the Sixth Amendment.
I'm not obligated to answer any of that stuff. I told you, I gave you the answer to that stuff by looking in the court rules. You're obligated to know the rules.
Sir, what you mentioned is statutory law. And if we are proceeding under some kind of statutory law, I motion that we dismiss for lack of a sworn complaint or anything signed by injured party. And in fact, where is the injured party? Is the officer present, and who is the injured party in this case?
The officer is not required to be present today. It is a pretrial day. I'll hold that, dismissal motion in abeyance until the date of trial. If the date of trial, if there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here?
Yeah, you're here.
Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint one.
Well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
Young man, you gotta go do your homework, okay? And it appears that you're taking this position and you're adamant about this position, and you're free to do that. Now, whether you're gonna win at this position, that's gonna be up to what you say in your brief, and how it relates to the law, and we'll make a decision on that stuff, okay? But at this point, you need to educate yourself, because you seem like a very articulate, educated young man. You need to educate yourself on court rules and procedure. Until you get it correct, we can't talk, because we have to be speaking the same language, okay?
I mean, that's the main thing I'm trying to understand here, sir. Is this a common law criminal procedure
I'm giving you some direction on.
Well, sir, I don't know which rules. If you could tell me where I could find the rules for
I told you, go to Michigan court rules. They got Michigan court rules.
They have rules for criminal procedure under statutory law.
Yes, very much so.
Could you please direct me to that?
Are you really asking the judge to walk you step by step through research you claim you already mastered to earn a law degree? The court isn't there to redo your homework or guide you through basic legal reasoning. The judge has already pointed you in the right direction. From there, it's your responsibility to do the work, understand the law, and present something coherent.
I've already directed you to it. Michigan court rules. There's a book that's over 1,000 pages, and it'll answer, well, close to 1,000 pages. It has those questions outlined in there. You're expected to know
Are
that.
those Michigan court rules, is that statutory law?
I'm not gonna keep going back and forth with you, sir. Whatever motions that you have, that's how you speak to the court, through motions. And whatever motions that you have, I will review it. I read all the motions that come across. I check all the law myself. And if you have some law, I would suggest that law that you're saying that we don't.
Your Honor, there is no international contract. I mean, we've asked the prosecutor to produce an international contract that would bind me to this statutory proceeding. And I'm not aware of any contract. In the absence of such contract, I motion that we dismiss this case.
So according to his logic, it's almost like he's handing himself a get-out-of-jail-free card for something as serious as murder, claiming the law doesn't apply because there's no complaining witness and no signed personal contract with the state. But that's not how any legal system works. Criminal laws don't depend on individual agreements or private consent, they apply universally. The moment you participate in society by using public roads, accessing public services, or even invoking your rights in court, you are operating under the legal framework that makes those rights possible in the first place. You can't selectively accept the system when it benefits you and reject it when it doesn't.
And for the record, I would just
in order to, you can move to the circuit court, and you can appeal my decision as it relates to that. But we're not going to keep on going back and forth.
I think we should move this case to federal court. As I stated, if the city is the injured party.
File a motion so I can, on your removal motion, file a motion.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time, And there's been no evidence of any jurisdiction. And I don't understand why, you're insisting on, moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. Well, I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest, and you don't have to show up. I mean, you'll have to deal with that then. But at some point, you're going to have to deal.
Under what grounds, under what basis are you putting a warrant out for my arrest?
He's not denying the request out of confusion. He's denying it because there's no willingness on the other side to actually listen. Instead of talking over the judge and misreading the situation, the issue is pretty straightforward. The court is making it clear that if there's no intention to appear at future hearings, there's no reason to continue with formal warnings or delays. In that case, the judge can proceed directly with issuing a warrant for arrest, because ignoring court obligations doesn't pause the legal process, it escalates it.
I didn't say I was going to put a warrant. I said, if you're telling the court that you're not going to come back to any court dates, then that's up to you. All I can do.
What I'm saying, sir, is I don't wish to delay this any further. There has been no proof of jurisdiction. There is no live injured party. I mean, there's a claim that the city of Detroit is an injured party, but I'm not aware of any international agreements or contracts that I've entered into with the city of Detroit. And the prosecutor can't provide that. And it seems like there's a bias going on here, because flat on his face, the prosecutor hasn't even spoken on this issue. And you just insist that we move to another court date. And I don't understand. I mean, your oath of office is to uphold the Constitution. And what I'm asking is
what you're saying in essence is that I don't have any authority.
I'm asking you to prove your authority.
Let me give you some straight advice. Having seen enough courtroom proceedings, this pattern is easy to recognize. What was just said is exactly the kind of argument that allows a judge to shut things down decisively. First, it reinforces the court's authority and jurisdiction over the case without any ambiguity. And second, it effectively turns the situation into a real-time example for everyone in the room of how not to approach legal proceedings.
I'm
asking you to prove your authority. I'm trying to understand where your authority is coming from. And you're failing.
Read the Michigan court rules, read your statutes, read the Constitution over again, and you'll find that.
As I said before, I'm not asking you for legal advice or where
and the Michigan Constitution.
You have, if you have a legitimate jurisdiction, I'm asking you, is it a criminal jurisdiction under statutory law, or is it under the common law?
All right, we're gonna give them a trial.
And you will not answer that question. Your Honor, we cannot proceed until I understand the nature and cause of the action against me.
I'm gonna say this one last time to you, sir. Go, and if you want to speak to the court, if you have any objection to the court and these dates, and if you don't feel that these dates are lawful, and if you, whatever your claim is that you're stating, you speak to the court through motions. I want that, and those motions that you're entertaining on the record right now, I've dismissed some of them already. I want you to file those motions with the court.
Under no basis.
So that the court can read your motion and make a ruling and give the city attorney an opportunity to respond. If you do it the proper way, you might learn something. But I don't think that the way that you're going, that you're even if they show you documentation like it is in black and white, you're not going to believe that anyway. That's the perception that I'm getting from you. So I'm going to set these dates. It's going to be up to you whether you want to come to these court hearings or not. And if you don't come to the court hearings, the only recourse I have is to issue a warrant for failure to appear. Okay, so
sir, I still have this same question that you keep failing to answer, and without that question being understood,
and that's it. I'm done talking about it. Okay, that's it. So I'm going to set a motion.
Let the record show that the judge has refused.
Listen, sir, don't interrupt me again. Okay? Don't interrupt me again. Let's set a motion date for.
Do not consent.
please do not say anything else, sir.
Sir, I'm exercising my Sixth Amendment right. The Sixth Amendment, exercise of an amendment right cannot be converted into a crime, sir.
I'm holding you in contempt of court, sir.
As I stated before, I'm trying to understand the jurisdiction of the
I'm not
court
going to deal with you. You're going to jail.
as pursuant to
Let's pull out the contempt
the Sixth Amendment.
Whatever paperwork we need to do and fill it out, we're going to fill it out this time. I'm holding your client. Well, Mr. Berry, you are, I guess, not representing this client because this client is probably, do you want the representation of a lawyer, sir, at this point now, sir? Because now you're looking at 30 days in the Wayne County Jail. Do you want the representation or not?
Facing 30 days and actually being sentenced to 30 days are two very different outcomes, and right up until the last moment, there was still a chance to change the direction of this case. All it would have taken was accepting the free legal representation offered. In reality, most people in that situation wouldn't hesitate to take that option. But not Lockhart. He insists on treating himself as a legal expert, and in doing so, he turns what should be a straightforward defense into a special appearance that only complicates his own position in the courtroom.
Please let the record show that I have attempted to understand the jurisdiction of this court, and this court has refused me that answer. And apparently it is a jurisdiction only understood to bar members and licensed attorneys. This is a direct violation of the Constitution, and I do not consent. I do not agree. That's it. Your Honor, I do not wish to be held in contempt.
It's too late.
I've merely asked a very basic, simple question, and you have refused to answer it. I feel as though the court is trying to constrain me to an unfair plea in absence of my understanding of the nature and cause of the action against me. Sir, did you receive the documents that I sent you asking for your anti-bribery statement? Hello.
I'm going to order you to report to the Wayne County Jail today.
I do not accept.
And honestly, most people who end up facing jail time for contempt don't ever accept the court's authority in any personal sense, and that doesn't change the outcome at all. Acceptance is just a personal viewpoint, not a legal requirement. The court's jurisdiction doesn't depend on whether someone agrees with it or acknowledges it, it comes from the law itself. In other words, you don't opt in or opt out of jurisdiction based on belief, it applies by legal authority, not personal consent.
I do not understand the nature and cause of the action against me. You have told me this is a criminal jurisdiction.
Sir, please don't. I told you don't say. I'm gonna add some more days if you keep on talking. You already got 30 days.
I don't understand, sir.
I'm adding more if you keep on talking. Please do not say anything else.
I'm sorry, Your Honor. It happened very fast.
It's happening again right now on the record. So those are the reasons
I'm just
that I
apologizing.
find, again, another contempt. And it just continues to happen. And I'm going to, now, if you have one more interruption with me, sir, I'm going to add another 30 days to that. And you're looking at 60 days. You're going to get 30 days. Right now, you're going to get 60 days if you have one more interruption too. And it will be no early release. At this point, I'm going to order you to report to the Wayne County Jail. Sir, do you have any further questions?
I just want to make sure I can speak without being held in contempt or...
Yes, you may speak. I asked you, do you have any further questions, sir?
Thank you. Your Honor, I would just like to tell you, man to man, that it was not my intent to be in contempt. It's never been my goal. I try to do everything in accordance with the law. As you can see, I have filed documents. I've filed motions. I've requested information from the court, all in a desperate effort to wrap my head around the proceedings and what's going on here today. And I'm sorry if I may have gotten frustrated and not being able to understand the nature and cause and action against me. But
just again, that was not my intention. I look forward to handling this as amicably as possible.
Look at that, a soft-spoken sovereign citizen actually trying to offer an apology, or at least that would have been the case if he had stopped there. But instead, he keeps going, and in the process turns what could have been a simple apology into something completely contradictory. Rather than taking responsibility, he continues speaking and effectively shifts blame onto the court, suggesting that his own contemptuous behavior was somehow triggered by their supposed misunderstanding of the law.
I think that the record will show, I think that the prosecutor will agree that there is no international contract to which I'm tied under statutory jurisdiction. And I would love to see it. I would love to see that evidence. But also, we covered the fact that the city is the injured party or the plaintiff. And this would be an improper venue anyway. But I appreciate your advice on handling that and moving forward with motions. I will be doing that. But again, this thing of contempt, it's just, as one man to another trying to understand and stand on my constitutional rights and exercising them. And I feel today, as what's happened is my pursuit in doing that has somehow been converted into crime against me, which is a tragedy in anyone's eyes, So I cannot consent to moving forward because I still do not understand the nature and cause against me. And I will be communicating in writing, and maybe, someone can give that to me in writing. We can go from there.
So in the end, it turns into a classic sorry, not sorry situation, an apology in words only, with no real acceptance of responsibility behind it. And if anyone was expecting Judge Perkins to be influenced by that kind of statement or suddenly become lenient, they clearly don't understand his approach in the courtroom at all. He doesn't base decisions on performative apologies or empty explanations. He responds to conduct, facts, and compliance with the process, not theatrics.
All right. And the court has heard all of what I respect the fact that you're trying to use the system and you're trying to operate by your understanding of the system. And the court is not trying to impair you in any type of way to present any claims that you may have. I continually referred you to the Michigan court rules, the Michigan Constitution, the United States Constitution. You want to find jurisdiction, you want to challenge jurisdiction, and I told you if you want to challenge that, you're free to do that. The court is never going to impair anybody to challenge any of the allegations that are held or that are brought against them. But there is a procedure, and whether you want to, you got to play by the rules, sir. And whether you accept the rules or not, that's not going to change the rules and the stuff that has been codified and the stuff that has been litigated and argued for over 2 centuries. The rules are not going to change for your position. Now, I asked you to continue, not say anything. I tried. I don't know what position you're really taking or where you're getting all this stuff from. And I asked you to put that stuff in motion. But when I asked you to please be quiet, please, I give you ample time to speak. I have not impaired your ability to put what's on the record, but you continually say the same thing over and over. And then when I ask you to please be quiet, and when I tell you that I'm going to hold you in contempt, if you're not quiet, and you continually go over and over and disobey what the court is trying to say, then I have left with no other option to do what I've already done. So you have an absolute right to attorney. I gave you Mr. Very, 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 very good attorney. Now, whether you want to listen to his advice or not, you have him there at your disposal. Other than that, sir, I don't know what to do for you.
Right.
So I'm ordering you to report to the Wayne County Jail by 5 p.m. today.
It just happened so fast, sir. I mean, I think we.
Hold on, what exactly do you mean by we? That's where the entire argument falls apart. There was no collective action or shared mistake being made here. It wasn't a we situation moving too fast or misreading the moment. It was a single person choosing to jump ahead of their own reasoning, speaking before thinking things through. And in the courtroom, that kind of misstep isn't just rhetorical, it has consequences. In this case, it's the individual who ends up accountable, and that's what leads directly to the next 30 days being spent in custody.
Well, maybe you may learn something from this. Maybe you may learn something from this, and that 30 days will give you an opportunity to go read and educate yourself on how this works. I got other people that are taking the same position as you, and I've afforded them the same exact opportunity as you have. And they did not do what you did today. They're holding fast on their position, and that's fine. I respect that. But I don't respect you interrupting me, and it seems that you really need an education on how this stuff works, and I'm gonna give you one today. Now, Mr. Berry, can you put your appearance on the record, please?
Yes, Your Honor. Elwood S. Berry, Jr., P28880, on behalf of this defendant.
Now, do you want to speak with Mr. Berry in a breakout room, sir, or not?
For the love of every window ever licked, just take the lawyer. Yes, he might already look like he's mentally calculating escape routes off the planet to avoid dealing with you as a client, but that doesn't change the advice: take the lawyer. Still, to be fair to Lockhart, giving up clearly isn't part of his vocabulary. He's not the kind of person who backs down easily, especially when he's already committed to pushing every argument to the very end, no matter how it looks from the outside.
No, with all due respect, Your Honor, yeah, I have the right to represent myself in my own person, and that is what I intend to do after having understood the nature and cause of the action against me.
Well, I've given you. We've gone over all the natures and causes. We've gone over the maximum possible penalty for these offenses. I gave you an opportunity to speak with how and explain to you how the court hears your representations. You can choose to file those representations or not. But in the meantime, I'm going to order you now. I gave you the dates. I'm going to order you now to report to the Wayne County Jail by 5 p.m. today to do those 30 days. All right?
I do not consent.
Alright guys, that's the end of the video. I did come across a couple of upcoming hearings, but it seems like there's been a shift. He may have finally ended up getting a lawyer. Maybe, just maybe, the time spent in custody actually taught him something about how the system works. Either way, we'll be keeping an eye on how this unfolds in future appearances. If you enjoyed the video, don't forget to like, drop a comment, and subscribe for more breakdowns just like this.